Hello. Hi. What's up? Can you guys see me? Can you hear me? Happy Monday. Ooh. Hi, 𝗵𝗃𝗃. Hey, beautiful Melly. I'm glad you made it, 𝗵𝗃𝗃. Hey, Mo. What's up, girl? I saw Debbie pop in here. 𝗍𝐶𝐶. What's up? I see Augie. Hi, Augie. Yay. I'm glad you guys made it. Yay. Okay, so tea is hot on the YouTube streets. We're going to go over some Diddy stuff today. I got all the documents, of course. First, we're going to review an article from a blogger who has been reporting on the Diddy case. And then I'm going to read the document that Cassie's lawyer put in about the gag order, all the stuff that's going on with the gag order. And then I'm going to read an article on the Cassie information. And then I'm going to read Diddy's lawyer's statement about the gag order, which is about 4 pages. And then we're going to review the NDA that Diddy signed for his team on March 25th, 2024. So we're going to go back in time and review the original non-disclosure so we know what everybody's talking about. And then I want to touch on a document from back in 2018, a lawsuit against Keith Raniere. He's also known as the Vanguard. And the reason I brought that up was because Diddy's attorney was his attorney in this case. And Keith Raniere was known to be someone in a cult. And I believe he was charged with trafficking and all kinds of charges. So I just want to make that connection. I have that document. It's a 22-page lawsuit, but since it's 2018, we're just going to review the main facts. I thought it was important to note that the person that is representing Diddy right now has a lot of experience representing these type of people. So anyways, what's up? Thanks for being here. Okay, let me see. Let me know if you can see. Yes, 𝗵𝗃𝗃. You knew about this. The NXIVM cult. Jaden Smith was also a Diddy victim. Yeah, I believe it. I do believe it. Okay, so I'm gonna share my screen. One sec. And we're gonna read the first Diddy document. And it's by that blogger. I just thought it was interesting before we talk about and go over the legal documents. So it says Diddy's lawyers push for gag order on witness Courtney Burgess in Fed case. And thanks for being here, guys. I just did want to say, make sure you hit that like button. We're going over Diddy documents. Absolutely. Okay, let's move on. So this was today, November 4th. Yesterday's attorneys for Diddy filed an emergency motion to gag witness Courtney Burgess. The motion follows Burgess's testimony and submission of evidence to the federal grand jury in the Sean Diddy Combs case. Burgess, I'm not sure if I'm saying that right, sorry, has turned over media drives alleged to contain Diddy and other celebs' sex assault videos and photographs, along with the manuscript written by Kim Porter. Burgess is being represented by attorney Ariel Mitchell. And this is a screenshot of the document we're going to be reviewing. And then it says perplexing denials. The proposed gag order references Burgess and his attorney giving several interviews as undermining Mr. Combs' right to a fair trial and the integrity of the grand jury proceedings. The letter goes on to allege that the videos and the pictures on the drives do not exist. The perplexing denial seems to be a part of the strategy to deny the existence of very real evidence. The letter continues to parse hairs over the use of the words documents, arguing that Ari's Mitchell's use of the words means they are not in possession of the videos. Further, the letter refers to Burgess's claims as pathetic extortion scheme, but does not explain how exactly anyone sought to benefit from the supposed scheme. It conflates Ariel Mitchell's earlier appearance in the media, referring to being asked to shop a particular video, which she refused to do, as being somehow related to 𝗟𝗏_Burgess's possession of the new separate video evidence. We can confirm per our previous exclusive interview on 10/26 with Ms. Burgess, he states he had not retained Ariel Mitchell prior to the grand jury subpoena later dated 10/24/2024. It appears to many that Diddy's lawyers are trying to confuse and manipulate the court with their twisted versions of events. Burgess had previously stated that he was willing to turn over evidence to the DHS and was looking for an attorney to do so. Seemingly, once Burgess secured representation, he did exactly as he was ordered to and appeared before the federal grand jury, turning over the evidence they had subpoenaed. Diddy's attorneys go on to argue that the freak-offs do not relate to either men or underage victims. This seems like another parsing of hairs as it ignores the human sex trafficking charges and tries to classify the freak-offs as separate and apart from the drugging and sexual assaults of unwilling participants. Contrary to what is being claimed by the defense, many witnesses have indeed stated that underage victims and men were indeed present at the Diddy freak-offs. Diddy's lawyers seem to be relying on games of semantics and mischaracterizations to achieve victim and witness shaming. Silencing a victim and a whistleblower. Many are calling the request for a gag order as both meritless and retaliatory. In our exclusive interview with Courtney Burgess prior to his federal grand jury testimony, he revealed he was shot by Diddy's associate over 10 times in his arm and his body, leaving him with serious injuries that still affect him to this day. Such a traumatic event would likely have sent most witnesses into hiding. Many critics have stated that attempting to gag Courtney Burgess and his attorney, Diddy's attorneys are sending a chilling message to all victims and witnesses. According to a source familiar with the case, Diddy should have thought of the repercussions before he committed his crimes in a country that has free speech. Diddy should have thought of all of this before drugging, assaulting, and videotaping his victims. Diddy's crimes have been open and notorious, involving hundreds, if not thousands of victims allegedly. There have also been allegations that Diddy and his associates have been selling the sex assault videos on the dark web to raise money for his defense. Coupled with the allegation that Diddy was allegedly involved in several unalivings, including Tupac Shakur and his ex-girlfriend Kim Porter, amongst many others, the environment for witnesses and victims to come forward can only be looked as perilous. With potentially thousands more witnesses coming forward against Diddy, including those with their own videos, photographs, and other types of evidence, Diddy's legal team seeks to set a dangerous precedent to quell victims. The source went on to state, as a society, we should not want other truth tellers and victims of Diddy to be silenced. What kind of precedence does it give if the whistleblower like Burgess is immediately attacked and quieted? Should every witness be disparaged? That is the reality of the situation. Rules for thee and not for me. This emergency gag order request follows the inflammatory remarks made by Marc Garagos, Diddy's off-again, on-again attorney, and father to Tony Garagos. Diddy's lead counsel on 10/31/24, Marc Garagos went on News Nation to cast doubt on the witness, Courtney Burgess, and the evidence he turned over to the federal grand jury. Many called out Marc Garagos as making a nonsensical argument with intent to discredit Mr. Burgess and the influence of the grand jury in favor of Diddy. Daughter Tony Garagos has previously represented convicted racketeer and sex offender Keith Raniere alongside Marc Agnifilo when they practiced law at mob lawyers Ben Brafman's law firm. Interestingly, Garagos and Agnifilo submitted a letter to the court during the case in 2019, responding to a potential conflict with Tony Garagos' representation of Keith Raniere and Marc Garagos' representation of 𝗟𝗶𝗸𝗲 because they are closely related. In this letter, the attorneys claim that the duties have been impaired by her close family relationship, referring to Marc Garagos being the father of Tony Garagos. And this is part of the lawsuit that we're going to read in a second about Keith Raniere. Many are referring to the father-daughter legal team as a plain dirty in the media, breaking the same rules they seek to impose on others. Whether the court will grant emergency gag order in the Diddy case remains to be unseen. Courtney Burgess' attorney, Ariel Mitchell, has stated to us that she plans to file a response to address the lies told by Mr. Agnifilo in the letter. This is part of the ongoing investigation. So, hey, what's up, YouTube streets? Shout out to you. What's up? Diddy did it. Diddy did absolutely did it. Okay, so now I'm going to read over the document from today. First, I wanted to read the one that Cassie's lawyer filed on 10/31, which was filed on the 1st by Wigdor Law Firm. This is Cassie's attorneys. And I just read that article and we made a connection to Keith Raniere. That's Marc Agnifilo, who's covering Diddy's case now. And we're going to read this statement from Cassie's attorney's law firm. It says, "Dear Judge Subramanian, we write as a counsel for plaintiffs in civil proceedings against defendant Sean Combs in response to Mr. Combs' criminal attorney request for an order prohibiting extrajudicial statements from the prospective witnesses and their lawyers. Docket number 43. Because such an order would appropriately silence victims who are proactively seeking justice through the civil justice system, because defendant Combs' family and representatives have themselves engaged in the release of extrajudicial statements, and because an order prohibiting attorneys from speaking about their cases would violate the ethical rules governing the practice of law, we respectfully ask that Mr. Combs' request be denied." So this is Cassie Venturas' attorney sending the statement out in regards to Diddy's motion to silence, which we covered on my last live. If you didn't, please go and check it out. And hi, welcome for you guys who are just here. If you've never been to my channel, welcome. If you've already been here, welcome back. I see YouTube streets, Augie, Tipsy, what's up? Clark, Military Mom, hi love. Thank you for being here. So this is the legal document from Cassie Venturas' attorney regarding the request for Diddy to silence everyone. Gag orders on victims are inappropriate. For both legal and moral reasons, silencing victims of sexual assault, abuse, and violence is inappropriate. The RICO Abuse and Incest National Record, citing data from the Department of Justice and Federal Bureau of Investigation, notes that only 310 out of every 1,000 sexual assaults are reported to police, meaning that no more than 2 of 3 assaults go unreported. The 2 individuals we represent came forward well before the federal investigation or criminal indictment of Mr. Combs became public. Moreover, after 2 of our clients came forward, Mr. Combs and his proxies made numerous attempts to the media about their accusations. To now order our clients to be completely silent about what they experienced would be an affront to their bravery and would be detrimental to the other victims of sexual violence who remain afraid to come forward. It is not clear exactly whom Mr. Combs seeks to silence with his requested relief, but his submission suggests that anyone who has claimed to have been a victim of Mr. Combs, regardless of whether their experience is relevant or connected to the criminal case at hand, must be prevented from speaking out about their allegations. The relief Mr. Combs seeks, therefore, extends far beyond the known or existent participants in this criminal litigation, and indeed could extend to individuals whose stories may not be relevant to the government's case against Mr. Combs. Such a restraint on speech implicates the constitutional rights of victims and their attorneys, and thus carries a heavy presumption against its constitutional validity. Such an order must be narrowly tailored and is only justified when there is a reasonable likelihood that pretrial publicity will actually prejudice a fair trial. Here, Mr. Combs seeks an order preventing prospective witnesses and their attorneys from making any statement concerning defendant, and in support cites to a plethora of comments made in various media publications, many of which were made before the grand jury indicted him. He has not shown with any reasonable certainty that this publicity will prejudice a fair trial. In fact, it is illogical to state that news that occurred before the criminal case was initiated could be restrained by this court. Nothing about his request is narrowly tailored. Indeed, Mr. Combs plainly asked for a blanket prohibition on speech on a large swath of unidentified individuals and attorneys without proposing any less broad proscription of alternative means to ensure a fair trial without restriction of the speech of individuals who are not participants in this litigation. As a result, his request should be denied. The relief Mr. Combs seeks is particularly inappropriate given that his family and representatives themselves have made extrajudicial statements to garner the exact attention he claims he wants to diminish. For example, last week, the day after Mr. Agnifilo filed his letter, Mr. Combs' son posted on Instagram, "The past month has been, quote unquote, devastated to our family," noting that Mr. Combs has been judged, quote unquote, based on accusation, but that the truth, quote unquote, will prevail. And on October 6, 2024, the defendant's mother, through her lawyer, Natalie G. Figgers, issued a written statement characterizing the criminal indictment in this matter as a narrative created out of lies and public lynching, and plainly states that the defendant is not guilty of the crimes he is accused of, and suggests that any conviction would fall into the alleged history of wrongful convictions. The defendant's mother further commented on her son's civil legal team's action in one of the civil cases that her son resolved months prior. Combs' argument that the attorneys for alleged victims of Combs' abuse create a circus-like atmosphere, but that his own family's attorneys and statements cause no impact, underscores the disingenuity of the relief sought. I didn't know this. I had not read this about, hey, Emily's dismantling Delulu's. Thanks for being here. I didn't know that Cassie's law attorney had filed this. Indeed, Mr. Combs' own attorneys have frequently made extrajudicial comments concerning this case itself. That is, unlike the comments he seeks to gag that are potentially unrelated to the criminal investigation or case before Your Honor, Mr. Agnifilo has proactively called the case a, quote-unquote, racially motivated prosecution, contending that his client is being targeted because he is, quote unquote, a successful Black man. Mr. Agnifilo has appeared in the tabloid publication of TMZ's documentary about this case, playing into the very media circus he claims prejudices his client's ability to receive a fair trial. So Cassie's attorney is like, no, that video where you were beating up my client, that's not exposing you because of everything else that your attorney's saying, right? Hey, Gracie. And hey, 𝗟𝗏𝗃, good to be here. What? Stop, Emma Clark. I see. Mr. Combs and his agents' abuse of extrajudicial statements alone undermines the legitimacy of the relief he now requests and is yet another basis for denying his request for a gag order. Combs seeks not only to silence victims, but also the attorneys who represent victims. The attorneys who participated in or have participated in the matter are, of course, bound by Rule 3.6 of the Rules of Professional Conduct, which prohibits extrajudicial statements that the attorney knows or reasonably should know and will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. The extraordinary relief Mr. Combs seeks is for attorneys not associated with the criminal case to be similarly prevented from making any statements, presumably including statements concerning those attorneys' active litigations against Mr. Combs in civil cases, and further asks that those attorneys remove information from online postings that fall under his proposed blanket restriction. An order preventing the attorneys for civil plaintiffs and other proceedings from speaking out about their representation or their client's litigation would, however, run afoul of victims' attorneys' ability to competently and diligently represent their clients as required. The ability to speak publicly about an attorney's work is, in fact, enshrined in the ethical rules. Indeed, attorneys may not themselves agree to any provision in any form of agreement that would restrict his or her ability to speak publicly about their cases, as doing so would violate Rule 5.6, which concerns restricting on an attorney's ability to practice. Rule of the Professional Conduct, which concerns restrictions on an attorney's ability. Oh, I'm sorry, I just repeated that. My bad. As one ethics opinions secondly states, once the matter is public, a settlement agreement may not impose confidentiality on otherwise public matters without violating the rule. A lawyer may not propose or agree to such a confidentiality provision. Okay, so this is just like the logistics. The opinion that further notes that a provision requiring an attorney to remove information about the public case from the firm's website similarly restricted an attorney's ability to practice, as the attorneys are always permitted to disclose public information that he or she handled if, for example, a potential client inquired as to the attorney's experience. Indeed, because discussions about an attorney or the firm's experience are part of the many firms' efforts to attract new clients, such restrictions would inhibit the ability of lawyers to advertise their services. Combs' request would have similar effects on the attorneys for victims of Mr. Combs who have used their expertise and experience representing victims of sexual assault to help their brave clients come forward and seek justice. These survivors and their attorneys should not be silenced and prevented from pursuing their claims publicly or from speaking their truth during the pendency of Mr. Combs' criminal case. We thank the court for its time and attention to this matter. That was the letter in response from Cassie's attorney, Cassie Ventura, Diddy's ex, to his gag order response. So, okay, we just went through that. Bear with me. Hey, Austin, what's up? I see you. What's up? Thanks for being here. Now we're going to read this article. We just read that part that Cassie's lawyers filed, right? And now I want to go back and read. I know you might be like, Melanie, why are we reading the same thing? But we're not. There's interesting stuff going on here. Okay, just bear with me. Oh, wrong screen. My bad. Welcome. Hi. Yeah, we're just doing our thing here. Don't judge me. What's up? Thanks, Austin. Okay, let's see. What did Cassie's lawyer say about the gag order requested by Diddy? So the letter we just read, and I just wanted to cover this real quick. We're just going to go through it. It says, Diddy's former girlfriend, Cassie Ventura's lawyer, has been opposing the disgraced mogul's attempt to enforce a gag order against his alleged victims and their legal representation in his ongoing case involving sex trafficking and racketeering. Ventura, who hit Diddy with a lawsuit in November of 2023, marking the first of litany of lawsuits in the same vein, was being represented by Douglas H. Wigdor at the time. According to 𝗟𝗃, Wigdor wrote to the court on November 1st to call out Diddy's family, including his mother and son Quincy, for their hypocrisy. So we just read that document, right? Per the outlet, Wigdor called into question Quincy's statement on Instagram, wherein he penned the following on October 22nd. The past month has devastated our family. Many have judged both him and us based on accusations, conspiracy theories, and false narratives that have spiraled into absurdity in social media. We stand united, supporting you every step of the way. We hold on to the truth, knowing it will prevail, and nothing will break the strength of our family. We miss you and love you, Dad. He also pointed to Diddy's mom's claim that the charges against her son were nothing but a smear campaign and a narrative created out of lies. According to Wigdor, it was unfair that the mogul's family was able to defend their father, Sean Combs' attempt to stifle the alleged victims from making their case was nothing short of ironic. Quote unquote, it is not clear exactly whom Mr. Combs seeks to silence with his requested relief, but his submission request suggests that anyone who has claimed to have been a victim of Mr. Combs, regardless of whether their experience is relevant or connected to the criminal case at hand, must be prevented from speaking about their allegations. He also directed this tirade to Marc Agnifilo, Diddy's lawyer, who once dubbed the case a racially motivated prosecution. So we kind of just read through that same thing as we read through the article, right? But I did think it was interesting because I don't follow Diddy's sons on social media. So, quote unquote, to now order clients to be completely silent about what they experienced would be an affront to their bravery and would be detrimental to the other victims of sexual violence who remain afraid to come forward. Wigdor's client contends she was abused by Combs in 2003. Cassie Ventura's lawsuit against Combs was based on allegations involving abuse, sexual assault physically. She contended that the abuse went on for the entirety of the relationship, which almost lasted a decade, and that with each year passing, it got worse. However, things were swiftly settled between the two out of court just one day after Cassie topic. So now I'm going to read the statement from Diddy's lawyer regarding the gag order. And this was filed 11/3. Oh, thank you, Tipsy. I appreciate you for gifting. What's up, Guilty of Crime? I just see you pop in. Good to see you. Okay, so now we're going to read the document from today that Diddy's lawyers filed to the judge. I appreciate you, Tipsy, for gifting. I don't see who can remember. Welcome. Who was it? Chris. Yay. What's up, Chris? Okay, so this was 11/3/2024, so yesterday. Dear Judge Subramanian, I apologize if that's wrong. We write on behalf of our client, Mr. Sean Combs, regarding the deluge of improper pretrial publicity that is undermining Mr. Combs' right to a fair trial and the integrity of the grand jury proceedings. As the court is aware, Mr. Combs filed a motion to restrict extrajudicial statements by potential witnesses and their counsels. ECF number 42, which the government has opposed, Mr. Combs' reply is due on November 8th, 2024. However, given the imminent harm of certain extrajudicial statements relating to the ongoing grand jury proceedings, we request that the court immediately restrain extrajudicial statements by potential witnesses and their counsel during their pendency of motion. So Diddy trying to silence everyone. I know. What's up, itty bitty? Thanks for being here. I appreciate it. I appreciate you guys being here. Over the past several days, a grand jury witness and his attorney have given multiple interviews, including outside the courthouse, immediately following his apparent grand jury testimony, making false and outrageous claims, including that the witness possesses videos of Mr. Combs involved in the sexual assault of celebrities and minors. This grand jury witness claims that he was subpoenaed after he made public statements on social media that he possessed videos of celebrities, including minors, being sexually assaulted. The subpoena also comes on the heels of attorney statements that she had been asked to shop a particular video and contact a celebrity in the video to see if they were interested in purchasing the video before it became public knowledge. Oof. That's rough. In anticipation of his testimony, the witness's lawyers made numerous statements to the media about testimony, including that the government had subpoenaed him to testify about the alleged videos. Immediately after his appearance before the grand jury, he and his lawyer were interviewed on the courthouse steps. That evening, they also sat down for an interview where the witness claimed that he has seen videos of 8 celebrities being victimized, including some who appeared to be minors, and all of whom appeared intoxicated. These stories have spread rapidly through the media and created the impression that such videos exist, which is false, and that the government is actually crediting his sensational claims, which is profoundly prejudicial. While the witness and his attorney eagerly spread false and unchecked claims in the media, they have avoiding subjecting their claims to verification through the legal process. For instance, the witness and his lawyers admitted that he resisted complying with the grand jury subpoena and only appeared after the marshals tracked him down. And when directly asked if they had the videos to back up their outlandish claims, the attorney responded, quote unquote, "That's what we're going to head over to do now. So we're having a hearing now to determine what we're going to do in terms of what documents we will have to turn over and what documents we do not." Her references to documents rather than videos is a clear indication that he they do not possess the latter. Indeed, this witness, who has never even met Mr. Combs, claims that he received the tapes from an unnamed individual who's subsequently shot and killed, along with the purported memoir of the deceased mother of Mr. Combs' children that has been denounced as fake. By treating these ridiculous claims as anything but a pathetic extortion scheme, the government is fueling fire of online conspiracy theories and making it impossible for Mr. Combs to have a fair trial. I'm sorry, I hadn't read this. I'm just reading it now with you guys. Yes, please hit that like button, help your girl out. This is wild. They really are trying to silence everyone. The government's main objection to the extension of the gag order to all civil litigants is that it would be extraordinary and beyond the purview of the local rule based on the assertion, which is unsupported by any legal authority and ignores the rule's facial applicability to lawyers for grand jury witnesses and the witnesses themselves. I'm trying to get past like the legal parts of this that we don't need to read from. The measures certainly may include restraining the speech of potential witnesses and their counsel, including those who ultimately may not be part of the criminal case, especially where the government refuses to identify who it plans to call as witness. As the Supreme Court explained in Shepard, a court can prescribe extrajudicial statements by any lawyer, party, witness, or court official which divulge prejudicial matters. Indeed, when the exercise of free press rights actually tramples upon Sixth Amendment rights, the former must nonetheless yield to the latter. This applies with particular force with respect to restricting attorney speech. Attorneys, as officers of the court, have a fiduciary responsibility to not engage in public debate that will redound the detriment of the accused or that will obstruct the fair administration of justice. Attorney statements also pose an increased threat to the fairness of a pending proceeding, since lawyers' statements are likely to be received as especially authoritative when in fact they are advocating for the client's slanted perspective. Moreover, it makes little sense that the civil litigants seeking to capitalize on the criminal allegations against Mr. Combs can nonetheless claim they are not involved in the criminal proceedings for purpose of the local rule. Those litigants and their counsel stand to financially benefit from a conviction and therefore are highly motivated to make damaging statements in the press. To say that those cases and those litigants are unrelated is illusory. The recent press, hold on, let me make sure I need to read this part. The recent press is especially damaging because it has occasioned another wave of leaks by law enforcement in violation of the court's order on October 25th. And then it lists an article by CNN on Thursday, which I'm assuming is a Diddy video. Indeed, even after the court's October 25th order, the leaks relating directly to the grand jury proceedings continue unabated. A New York Post article published on October 31st, 2024, attributed to the following, to a quote-unquote federal law enforcement source who is involved in the investigation. Hey, Jilly. They're all too happy to talk, says a federal law enforcement source who is involved in the investigation. We're asking them about their recollections of the freak-offs, what they are paid to do, and who else was involved. I'm surprised how many of them recall intricate details about what happened. And the next bullet point says, the source told the Post that many of the men who were in their 20s at the time of the parties, but are now in their 40s, have aged out of the skin biz, have offered similar details about parties, including the drugs that were allegedly supplied. Bullet point number 3. They were all encouraged to take Viagra and Cialis before the parties, said the source. They were expected to perform and were told if they didn't perform, they'd be thrown out of the party and not paid. Bullet number 4. Authorities are trying to determine if any of the participants in the Diddy freak-offs were underage or illegally coerced into performing. Last, we have to identify all peoples in the video, says the Fed source, and then we can figure out how old they were at the time and make sure that none of them were trafficked or threatened to participate. It's a long process, but we're making the progress. The government has been investigating for nearly a year, and as they are aware, their own allegations about quote-unquote freak-offs do not relate to men at the parties or as alleged underage victims. In light of the continuing prejudicial, extrajudicial statements by witnesses and their lawyers, and to the extent to which these press statements generate further government leaks, we respectfully request that the court enter the attached proposed temporary order restraining the speech of potential witnesses and their counsel. We respectfully request that the court enter the attached proposed temporary order restraining the speech of potential witnesses and their counsel. We appreciate the court's consideration. How do y'all feel about that? I mean, what if you were involved in a legal case and you were being silenced? How would that feel? I don't know. Maybe it's not the same thing since we're not Diddy, but nonetheless, I don't think that feels good, regardless of who it is. Okay, so I was able to dig up the non-disclosure agreement that Diddy has from, this is filed on 3/25/24. So this is in March. And I just, you're probably wondering, thank God. You're probably wondering why we're reading such an old document, but I wanted to go over it because I felt like all this stuff is being talked about, the non-disclosures and what can be talked about and what cannot. Well, let's see what everybody had to sign, right? Why not? Let's just review it real quick. Let me share it. There we go. He says, I think it's just also messed up. I know I've been. Thank you, 𝗍𝗶𝗸𝗲, for being here. Shout out to the mods. If I lay down any longer, I'm done. What does that mean, Marcus? Hey, Jojo, I didn't see you pop in here. What's up? If y'all can please hit the like button for your girl, please. Billy, is that you? It's me. Okay, so this is the standard Combs NDA, and this was filed in the court system on 3/25. So this is what, you know, they've all been signing. Hi, baby. What's up? What's up, everyone? Okay, let's see. Thanks for being here. I appreciate it. It says name, date, and email, and it's redacted. Okay. The confidentiality agreement is made and effective as of Friday, September 9th, 2022, by and behalf of blank. The term you shall include you, your estate, each corporation and or other business entity in which you have an ownership or beneficial interest, and any and all persons or entities owned and or controlled by you and or such businesses, and all of the respective heirs, executors, representative, administrators, employees, licenses, successors, and assigns. It's already way too much for me. I'm not signing no NDA. Oh yeah. Bye, Marcus, whatever. Let's see. It says, number 1, Sean Diddy Combs, aka Puff Daddy, an artist. Privacy is highly valued, and all efforts will be made to maintain confidentiality with respect to all information and other material of any kind, including without limitation the terms, conditions, and existence of this agreement, concerning and or related to directly and indirectly to the artist and or any person, corporation, and or other entity related to or affiliated and or associated with the artist personally and professionally, including without limitation of the family members, relatives, and past or present fiancés, husbands, wives, boyfriends, girlfriends, friends, and business associates, except for information of material publicly and intentionally disclosed by artist. So you have to sign this non-disclosure, and you're basically signing that you're not going to talk to anyone or anything related to this person. That is crazy. That's like crazy. You hereby irrevocably agree that you shall not at any time use or disclose directly or indirectly to anyone any of the following information: any information acquired by you in any manner or by any medium or means whatsoever at any time in the past, present, or future which concerns and or in any way relates to the artist, any artist parties and or artist business activities, entertainment activities, financial affairs and or personal life, and also all such information shall be deemed confidential, private, secret, and sensitive, and kept by you as confidential unless the artist otherwise advises you in writing an artist's sole discretion, and any and all information described in paragraph 1, including without limitation, pictures, recordings, records, documents, property, merchandise, or any other information related to the artist and or the personal or professional and or other activities of the artist or any artist party, whether prepared by or on behalf of you or otherwise coming into your possession, is and shall remain the artist's sole and exclusive property, and shall not be disclosed, removed, sold, disseminated, copied, or otherwise used and or exploited by or on behalf of you without artist's prior consent. Like influencers, models, etc., people actually sign this document. I'm good off going to the Diddy parties. I can't even keep up. I'm already confused. Without limiting the foregoing, without artist's prior written consent, you shall not and shall not authorize any third party to photograph, film, or otherwise record any sound, likeliness, or activities of the artist and or artist parties of any kind or nature, whether personal, professional, or otherwise, and or any activities during or related to any service of activity performed by the artist or any other artist parties. Okay, so I get it. We get it. This non-disclosure, which is filed by the court in March of this year, we get it. Anything at the Diddy parties is off limits. So clearly that was something going on there, which now we are seeing is true. It's like even the noise, the sounds. Without limiting the foregoing, you shall not, oh wait, I'm sorry, I think I already read that. You shall not and shall not authorize or facilitate any third party to, without the artist's prior consent, give any interviews, write or prepare or assist in the preparation of any books or articles, make any remarks of any kind, or create any materials in the media to or for use by yourself or any third party, which interviews, books, articles, remarks, and or materials concern, discuss, or reference artists or any artist parties in any matter whatsoever. You hereby grant, convey, transfer, and assign to artist all worldwide right, title, and interest in and to any prohibited material, whether or not the same are used and or exploited, and regardless of the medium involved, an artist may register such copyright in his or her name. You shall not and shall not authorize or facilitate any third party to use and or reference artist and or artist parties' name or identity with respect to any transaction, sale of goods, or other solicitation, and without limiting the foregoing, you shall not at any time defame or disparage the artist and or the artist parties, and or use, disclose, disseminate, or confirm directly or indirectly to anyone any information on material which may harm, disparage, demean, or reflect negatively or poorly upon or cause injury to the reputation, character, or career of the artist or any of the artist parties. That's why people are so afraid to speak out, because they sign this document basically signing that if you sign, it's a lawsuit. The foregoing expressly includes without limitation communications appearing on the internet via blogging and or social networking sites such as Facebook, Twitter, and Instagram. Without limiting the foregoing, you shall not, without the artist's prior written authorization, distribute, publish, or permit the distribution or publication of photographs, videotapes, films, audio tapes, or any other record recorded sound or image, or any other material of the artist or the artist parties. Copy or excerpt or otherwise use and or dispose of any artist or the artist party's material, including any property or materials in possession or control that belong to the artist, and that upon expiration or termination of the relationship with or in connection with the artist, you or your legal representative, successors, or assigns shall promptly deliver possession to artist in good condition any such property of artist and or artist parties and or other record copies, experts, and other aforementioned materials that are in your possession or control. No way. This is wild. 2, you acknowledge that due to the nature of the entertainment industry, any disclosure or dissemination by you of any of the information or material described in paragraph 1 will deprive the artist and or the artist parties of the right to use such information or material. You expressly agree that if you breach or threaten to breach paragraph 1, artist and or the artist parties would suffer immediate irreparable harm and injury which could not be adequately compensated by any award of the monetary damage. In addition to all other rights or remedies available to artists and or the artist parties, artists and or the artist parties shall be entitled to injunctive relief and all other remedies provided in such events by law or equity. Such remedies shall include, without limitation, the right to prevent dissemination of any information or materials as described before. You agree to execute any documents and take such other actions as may be reasonably requested by the artist and or the artist parties to further evidence. You hereby appoint artist as your attorney in fact, with full powers of substitution and delegation to execute all such documents which you fail to execute within 5 days after artist and or artist parties request therefor. Number 3, the term of this agreement and duty to keep all information confidential and not use prohibited material shall commence on the first day above and continue for the life of the artist plus 20 years or 70 years, whichever is longer. Wait, let me read that again. The term of this agreement and duty to keep all information and not use prohibited material shall commence on the first date above and continue for the life of the artist plus 20 years or 70 years, which is longer. Number 4, your warrant and represent that you have the full right, power, and authority to enter into this agreement and you be bound by the obligations herein. Neither the execution, delivery, nor performance of this agreement by you shall conflict with or result in the default or loss of rights under any agreement or understanding to which you or any affiliates is a party or by which you or any of your properties may be bound. This agreement constitutes your valid and binding obligation, enforceable in accordance with its terms, and you have signed this agreement voluntarily without duress, coercion, and undue influence. This agreement shall be deemed to have been entered in the state of New York, and its validity, interpretation, and legal effect shall be governed by the laws of the state of New York, applicable to contracts entered into and performed entirely therein. The New York courts only will have jurisdiction over all controversies regarding this agreement and any other action or proceeding which involves such a controversy, which will be brought solely in the courts located within the states of New York. You hereby consent to the personal jurisdiction of such court and waive any objection based on the personal jurisdiction, venue, or forum nonconvenience. This agreement embodies our entire agreement with respect to the subject matter thereof. This agreement shall inure to the benefit and the binding upon the parties hereto and their respective heirs, executors, administrators, representatives, owners, licensees, designees, and successors and assigns. This agreement may not be transferred or assigned in any manner by you or attempted by transfer or assignment should be deemed null and void. You agree to defend, identify, and hold artists and the artist parties and their respective parents, subsidiaries, affiliates, licensees, assignees, and their officers, directors, members, managers, agents, distributions, and employees harmless from and against all liabilities, damages, judgments, losses, costs, and expenses of any kind or nature whatsoever, which may be sustained or suffered by or secured against any of them by reason of based upon or relating to any breach of any of the provisions, representations, or warranties contained herein, or by the virtue of inaccuracy and or breach of the representations and warranties made by you hereunder to any third party on behalf of the artist and artist parties, or any claim, action, or proceeding asserted or instituted relating to or growing out of any such breach. This is an important legal document. You acknowledge that you have reviewed this agreement with your legal counsel, knowingly and or knowingly declined the opportunity to do so. Your failure to review this argument with your legal counsel shall not impair the legally binding nature of this agreement, and you have fully read and understand and voluntarily accept all terms of the conditions of this agreement. You certify that you are 18 years of age older, accepted and agreed, including acknowledge and receipt of all consideration. So that's what the non-disclosure is, if you want to be related to Diddy or anything related to Diddy. So I thought that was important to cover that, because we've been talking about it and what does that really entail. Last document. We're going to go over this article by The Hollywood Reporter. I want to share it. Oh, my bad. That's the wrong one. So wait, let me see. Marcus, I agree. Nobody deserves to be treated, and Diddy and his scumbag friends treated these people. Yeah. It's best when they all come forward and be honest. Well, what do you think about all of this? I'm curious. Okay, I'm going to read this article by The Hollywood Reporter, and then we're going to read, I don't have any more documents. We're just going to highlight another lawsuit after this. So I did want to cover, like I said, Diddy's lawyer has covered another big person in the media, Keith Raniere, back in 2018. And he was, someone said, in the NXIVM cult. I'm not familiar with who he is, but he was known for trafficking and RICO charges, and it was very similar to Diddy. And I did just want to highlight that as well. So this is an article by The Hollywood Reporter. And it says, Diddy's defender, how his legal team will fight sex trafficking racketeering charges. Marc Agnifilo, who faced the feds in a similar RICO case involving leader Keith Raniere, has a long history of representing high-profile figures, including Martin Shkreli, Dominique Strauss. He spent nearly 2 decades working for ex-Harvey Weinstein lawyer Ben Brafman. The lawsuit filed against Sean Combs by singer Cassie Venturas, advancing staggering accusations of sex trafficking and a decade of physical abuse, sent shockwaves through the music industry last November and ignited a flood of legal claims against the mogul. It also sparked one of the highest profile federal sex crimes investigators in the years. And on September 17th, prosecutors detailed what they had found, which was a vast criminal enterprise through which they say Combs, also known as Diddy, trafficked women with the help of his business empire from at least 2008. He pled not guilty to the charges the following day. We know that's been going on for way longer, right? If you've been following this, allegedly. If convicted, Combs, 54, faces 15 years to life in prison. The founder of the Bad Boy Entertainment, recognized as among the chief drivers of the commercialization of hip-hop with a network estimated as high as $1 billion, has turned to Marc Agnifilo, a do-it-all defense lawyer with extensive experience litigating complex racketeering cases involving criminal enterprises like the ones Combs is facing. Agnifilo, an ex-Manhattan assistant district attorney and former supervisor at the U.S. District Attorney's Office, is known for spending nearly 2 decades working for Combs' longtime lawyer, Ben Brafman, who has represented Harvey Weinstein and his boss's biggest cases, Dominique Strauss-Kahn and Martin Shkreli. I need to look into who those people are. Brofman, now in his 70s, represented Combs for a decade. His client nicknamed him Uncle Benny. He successfully defended the mogul in the criminal case that stemmed from a 1999 New York club shooting and went on to handle headline-generating civil lawsuits for Combs in the ensuing years, including one for allegedly assaulting a partygoer and another for purportedly threatening a longtime choreographer while filming his reality show Making the Band. Brofman also represented Combs when Ventura, an ex-girlfriend, once signed to his label, filed a lawsuit that kickstarted the criminal probe. Earlier this year, Agnifilo and his two colleagues struck out on their own to form a boutique criminal law practice. He and another of the departing lawyers now leading Combs' defense, Tenny Gallegos, have a history of defending conspicuous figures accused of major crimes, including former Goldman Sachs managing director Roger NG, and I don't know what that means, founder Keith Raniere, who was convicted of sex trafficking. That legal team brought together those whose criminal defense lawyers known for aggressive approaches in representing men accused of violent sex crimes like 𝗟𝗲 and Jennifer Bojine, R. Kelly and Bill Cosby's victims. I specialize in sensitive and high-profile matters, he explained of his métier, much of which involves charges brought by the Southern District of New York, including cases involving the black market website Silk Road and the international prostitution ring connected to the downfall of Governor Elliot Spitzer. The same U.S. Attorney's Office has also indicted Combs. The duo was retained by Combs in March to coordinate his defense in the federal prosecution, Agnifilo said at a September 17th court hearing. Almost immediately, they launched an investigation into what they figured the government's indictment would look like. They've interviewed several witnesses over the past 6 months. Expect Agnifilo to go on the offensive. The women and the sex workers who engaged with Combs did so consensually for their own reasons, whether that was money, career advancement, or romantic interest in the megastar. We're not merely making general denials of guilt, he wrote in the September 18th letter to the court over Combs' denial of bail. Rather, we are advancing detailed, specific facts that undermine the government's theory at its core. By his thinking, the sex trafficking charges revolves around a single accuser, Combs' ex-girlfriend Ventura. And while their 10-year relationship was toxic, there were no sex crimes. Agnifilo said, employing the same playbook as many celebrities accused of sexual assault, he's expected to portray Ventura as a scorned ex-girlfriend who sought a quick payday by threatening to sue Combs and publish a tell-all book recounting her time with him. We are now in the position where the only person alleged to be a victim extorted Combs and profited millions of dollars, the lawyer wrote in the same filing. We have countless written communications that tend to negate any lack of consent and any coercion. The court will determine at a later stage whether the lawsuit and settlement will be allowed in trial. Combs will argue they're relevant to Ventura's credibility, while prosecutors will argue that they'll bias the jury. Consent will likely be a battleground during the trial. Agnifilo claimed that the government tellingly didn't allege that Ventura never agreed to bring in a third party into their sexual encounters. When interviewed by the 6 of these men, denied seeing any red flags, including coercion, anyone being overly intoxicated, and lack of consent, according to the lawyer. Does everybody have experience being intimate in this way? No, Agnifilo said at a September 17th hearing. Is it sex trafficking? No, not if everybody wants to be there. Undermining the theory is Ventura's account of her relationship with Combs, which presumably can't come into trial through her testimony. In her lawsuit, she alleged she was trapped by Combs in a cycle of abuse, violence, and sex trafficking, citing multiple incidents in which he allegedly punched, beat, kicked, and stomped her as a means of control. The mogul would demand Ventura to perform sexual acts on other men, she claimed. Sometimes Mr. Combs would pay to fly male sex workers to his location, including to multiple cities in the U.S. as well as abroad, stated the complaint, which helped form the basis of the racketeering charges from the prosecutors by alleging that Combs would require his staff to help make these arrangements. So I just wanted to kind of touch on that article because I'm going to show you guys the lawsuit that Marc Agnifilo represented back in 2018, Keith Raniere. It does, I mean, I'm not saying it's related. I just think it's interesting that they're very similar charges. And on this one, it's pages long, but I'll just read like the allegations and then the intro, just so you guys can kind of get an idea. This was filed in 2018. United States versus Keith Raniere, the Vanguard. In or about between February 2016 and June 2017, both dates being approximative and inclusive within the Eastern District of New York and elsewhere, the defendant Keith Raniere, together with others, did knowingly and intentionally conspire to recruit, entice, harbor, transport, and provide, obtain, maintain, patronize, and solicit persons, to wit, Jane Does 1 and 2, individuals whose identities are known, and the undersigned in the affecting interstate of foreign commerce, knowing that the means of force, threats of force, fraud, and coercion, as described in Title 18 and one of the more combinations of such means, would be used to such persons to engage in one or more commercial sex acts. In or about February 2016 and June 2017, both dates being approximate and inclusive, the defendant Keith Raniere, together with others, did unknowingly and intentionally recruit, entice, harbor, transport, provide, obtain, maintain, patronize, and solicit persons, to wit, Jane Does 1 and 2, whose individuals' identities are known to be undersigned in and affecting interstate and foreign commerce, knowing that the means of force, threats of force, fraud, and coercion, and one or more combinations of such means would be used to cause such persons to engage in one or more commercial sex acts. So I'm going to go to the allegations. I'm interested in this, so I have never heard of this case before. Oh, he's the one who was in the cult. Oh, whoa. We might have to like read through this. This is crazy. I hadn't looked over this. Okay, let me back up because I just saw some pictures too, and I'm like, In or about 1998, the defendant Keith Raniere, also known as the Vanguard, founded Executive Success Programs, an ESP series of workshops designed according to its promotional literature to actualize human potential. In or about 2003, Raniere founded an organization called NXIVM, in which served as an umbrella organization for ESP and other Raniere affiliated entities. This is a lot darker than I thought. I might have to just read through this. On its official website, NXIVM is described as a professional business providing educational tools, coaching, and trainings to corporations and people from all walks of life, and describing its philosophy as a new ethical understanding that allows humanity to rise to its noble possibility. So this is a person who was charged to be running a cult and sex trafficking, and this person was defended by Diddy's lawyer. So that was my point, is I just wanted you guys to make that connection. But this lawsuit is actually fairly interesting. NXIVM is headquartered in Albany, New York. NXIVM operates centers all over Americas, including the United States, Canada, Central America, and Mexico. Raniere and many of the members live approximately 20 miles outside of Albany, New York, in Clifton Park. A number of NXIVMs were residents of the Eastern District of New York when they were recruited, and NXIVM held promotional recruiting events in New York. Each of the Raniere entities offers classes promising personal and professional development. Based on information obtained during the course of this investigation, classes offered by Raniere affiliates entities can cost up to $5,000 for a 5-day workshop. Participants are encouraged to keep attending classes and to recruit others into the organization in order to rise within the ranks of NXIVM and reach certain goal levels. These levels are remarked by different color sashes, which are worn by the NXIVMs, as well as different responsibilities and privileges, including the ability to receive a salary or commissions. Many NXIVMs found themselves in debt from the courses they are required to take, and some are obliged to take jobs working for NXIVM in order to continue taking courses and ostensibly pay for their debts. However, because of the high price of the courses and the pressure to continue taking them, participants often would continue to accumulate new debts and remained obliged to NXIVM. NXIVM operates largely in secrecy. NXIVMs are often required to sign non-disclosure agreements and make promises to not reveal certain things about NXIVM's teachings. NXIVM maintains features of multi-level marketing scheme, commonly known as a pyramid scheme, in which members are recruited via a promise of payments or services for enrolling others in the scheme. Raniere formerly ran a multi-level marketing scheme called Consumers Byline, which was forced to close after a settlement with New York Attorney General in 1997, approximately 1 year before ASP was found. Oh my gosh, you guys know about this. 𝗵𝗃 said Vanguard was a cult and an MLM. What? See, I'm like into this stuff. This is the same person who's representing Diddy who represented this person. Raniere referred to as a vanguard by NXIVMs every year. In August, NXIVMs pay $2,000 or more to gather in Silver Bay, New York to celebrate Vanguard Week in the honor of Raniere, whose birthday is August 26, 1960. Based on information obtained during the course of the investigation since ESP's founding, Raniere has mentioned a rotating group of 15 to 20 women with whom he maintains sexual relationships. These women are not permitted to have sexual relationships with anyone but Raniere, or to discuss with others their relationships with Raniere. Wait. Based on the information, Raniere has maintained a rotating group of 15 to 20 women with whom he maintains sexual relationships. These women are not permitted to have sexual relationships with anyone but Raniere, to discuss with others their relationships. Some of the NXIVM curriculum included teachings about the need for men to have multiple sexual partners and the need for women to be monogamous. In or about 2015, a secret society was developed with NXIVM called DOS or VOW. DOS is an organized criminal group that operates in the Eastern District of New York and other parts of the United States, Canada, and Mexico. DOS engages in its activities, effects, and interstate foreign commerce. DOS operates a pyramid with levels of slaves headed by masters. Slaves are expected to recruit slaves of their own, who in turn owe service not only to their masters, but also to masters above them in the DOS pyramid. Based on information gathered over the course of this investigation, including Raniere's own admissions and emails between Raniere and other members, Raniere alone forms the top of the pyramid at the highest master. Other than Raniere, all participants in DOS are women. Raniere's status as head of the pyramid was newly concealed from all newly recruited slaves other than those directly under Raniere. Okay, well, you got a little taste of that lawsuit from 2019 by a cult member who was represented by Diddy's lawyer now. I believe this person's had to serve like 120 years in prison or something. I know, that was interesting. I might have to finish reading that. I wasn't sure if you guys were interested in me reading that, but we can continue that on another live because it seems like that's something I might have to deep dive. But it came across on, just the Diddy stuff in relation to who Marc Agnifilo represents. It is madness. Anyways, okay, so I believe we're done. We got through the two documents today. I appreciate you guys for being here. That took us like an hour. Hey, Juicy, thanks for popping in. I appreciate you guys for being here. Make sure you hit that like button. I will be live soon again. I have another true crime live coming up, so I hope you guys can make it. Make sure you hit that like button on your way out. We did just cover the Diddy documents. One from Cassie's law firm, Cassie's attorney's law firm, and then one from Diddy's law firm. Good night, Jojo. I know, 𝗵𝗃. That's a very interesting case. Thank you, Marcus, for being here. Yeah, I'll see you guys in a little bit if you can make it for the next live. If not, then I'll catch you on the next one. Make sure you hit that like button on your way out. Bye.